Hello and welcome to the next video about Jeremy DeWitt. This video will explain a little clearer the previous sentences he has already dealt with, but I will also break down and explain all that he is still facing. For those who have watched my previous videos, you know that Jeremy is going on trial as of right now, hopefully not delayed again, on July 21, 2025 in front of Judge Michael Kranick, the same no-nonsense judge who handled Sarah Boone. This case has been delayed several times already, so fingers crossed no more. As this video progresses, I will be explaining the upcoming charges and breaking it all down as to what they mean and what could possibly happen. I hope you enjoy. Rehearsed. And behind the curtain, the insurance company was about to write the final check on a story he never saw coming. Jeremy DeWitt's legal history is a tangled web of impersonation, deception, and repeated run-ins with the law, especially in Florida. Here's a breakdown of his most notable court cases and convictions. DeWitt has been arrested numerous times for impersonating a police officer while operating his funeral escort business, Metro State Vehicle Protection Services. He was caught wearing police-style uniforms, carrying imitation firearms, and using vehicles with sirens and lights to lead funeral processions, despite not being law enforcement. In 2021, he received 18 months in jail, 4 years of probation, and a 6-month license suspension for these offenses. In 2024, DeWitt was sentenced to nearly 7 years in prison for violating Florida's sex offender registration laws following his 2005 conviction of sexual battery on a minor. Specifically, he failed to register a newly purchased vehicle, a black Dodge Charger, with the Florida Department of Law Enforcement, as required by law for registered sex offenders. Although the statutory maximum for this offense is 5 years, the judge imposed a harsher sentence due to DeWitt's extensive criminal history, which includes 12 prior convictions, many involving impersonating law enforcement. His defense argued he was unaware of the registration requirement, but evidence showed he had previously registered the vehicle under a different color, undermining that claim. This conviction adds to DeWitt's long-standing notoriety in Florida, particularly for his repeated impersonation of police officers while operating his funeral escort business, Metro State Services. The judge's decision reflected not just the technical violation, but a broader pattern of deceptive behavior. Florida's habitual felony offender statute allows enhanced sentencing if the defendant has 2 or more prior felony convictions. The new offense occurred within 5 years of a prior conviction or release. The offense is not solely drug-related, which his wasn't. Under this law, a third-degree felony, normally up to 5 years, can be punished with up to 10 years. The judge clearly viewed DeWitt's record as a persistent threat to public trust and safety. DeWitt's case is a textbook example of how Florida uses habitual offender laws to escalate consequences for repeat offenders. DeWitt's 2024 state conviction for failing to register a vehicle as a sex offender earned him 81 months in Florida prison. Then in January 2025, he was sentenced to 41 months in federal prison for filing false tax returns related to his Metro State business. Here's the kicker. The federal sentence was ordered to run consecutively, not concurrently, with his state time. That means he started his 81-month state sentence in November 2024, and after that is done, he will start the 41-month federal sentence, so he will be locked up for 10 years before any hope of getting out. This is also before his upcoming trial on 9 more felony counts of the exact same charges. The judge cited DeWitt's dozen prior felony arrests, including multiple counts of impersonating law enforcement, as justification for the longer sentence. This marked yet another chapter in his long-running legal saga tied to his activities with Metro State and repeated violations of sex offender registration requirements. Those included 2003 impersonating a police officer that he was sentenced to 2 years. This was tied to his Explorer program days. A 2005 lewd/lascivious battery, victim 12 to 15, 1 year plus sex offender registration triggered long-term registration obligations. 2009 parole violation, sentenced to 4 years. 2021 impersonating a police officer, sentenced to 18 months plus 4 years probation, and included his license to be suspended. He has also had over 70 different cases in Orange County, Florida, as well as over a dozen cases in Osceola County, Florida, resulting in numerous days in county jail, probation, fines, loss of license, dismantling of his business, and numerous other lawsuits against him civilly totaling thousands and thousands of dollars. And now the 10-plus years he recently got sentenced to, and with Florida abolished parole for most crimes committed after 1995, which means he's not eligible for traditional parole. He may qualify for gain time, early release for good behavior, but that's limited and discretionary. His federal sentence for tax fraud is consecutive, meaning it starts after the state sentence ends. In short, barring appeals or sentence reductions, DeWitt is likely to remain incarcerated well into the early to mid-2030s. And that is before he has his upcoming trial for these 9 felony charges. Count 1. Organizing, planning, or participating in an intentional motor vehicle collision. Second-degree felony. Florida Statute 817.234 specifically. This statute targets individuals who deliberately cause or fake car accidents with the intent to defraud insurance companies. This statute criminalizes orchestrating or participating in a fake crash as part of an insurance scam. The fact that it's charged as a second-degree felony means it carries serious potential penalties, up to 15 years in prison under Florida law. Counts 2 and 3. False and fraudulent motor vehicle insurance application. Statute 817.236. Third-degree felony. This statute criminalizes providing false statements in an insurance application, for instance, misrepresenting who will drive the vehicle, previous claims, accidents, or where the vehicle is primarily kept. It's a third-degree felony in Florida, punishable by up to 5 years in prison, a $5,000 fine, and 5 years of probation. Jeremy DeWitt is charged with 2 separate violations under this statute. March 22, 2020. March 29, 2020. In both instances, he allegedly submitted falsified details to an auto insurer. These filings were not isolated. They're part of a broader scheme involving staged collisions and other fraudulent claims, like the October 2020 crash. This statute likely serves as a keystone in linking paperwork manipulation to physical incident staging. He entered not guilty pleas to both counts. Count 4. False and fraudulent insurance claims. Statute 817.234. Third-degree felony. This statute refers to knowingly filing a false claim with an insurance company, and it makes it a third-degree felony to knowingly submit or help submit any false, incomplete, or misleading information to support an insurance claim. In this case, DeWitt allegedly filed a fraudulent auto insurance claim on October 11, 2020, the same date tied to the staged collision charges listed earlier. The charge appears to be directly connected to the intentional motor vehicle collision, meaning the claim may have included false statements about how the crash occurred, who was involved, or the extent of damage or injury. This isn't a one-off. It's one thread in a coordinated pattern. It directly complements other charges like staging a crash, false insurance applications, and organized scheme to defraud. Together, these outline a narrative where DeWitt is accused of fabricating or manipulating both the physical event, the crash, and the paper trail, applications and claims, to extract money from insurers. This charge helps anchor how paperwork manipulation escalated into active crash staging, with each charge stacking into a broader insurance fraud strategy. Count 5. Failure by sexual offender to comply with registration requirements. Fail to provide motor vet info. Statute 943.0435. Third-degree felony. This statute relates to a statutory obligation that registered sexual offenders keep their identifying information current, including details about their vehicles. It requires that registered sexual offenders must report all vehicles they own or routinely operate, even if not owned by them. This includes make, model, color, license plate number, and vehicle identification number, VIN. The information must be kept current and reported within 48 hours of any changes. Failure to provide this motor vehicle information constitutes a third-degree felony, with penalties of up to 5 years in prison, 5 years of probation, and/or a $5,000 fine. DeWitte was charged with this violation based on events dated March 22, 2020. The failure to disclose vehicle information wasn't an isolated administrative lapse. It's part of a series of charges reflecting patterns of deception and concealment, including fraudulent insurance filings and crash staging. This charge bolsters the prosecution's broader narrative that DeWitte actively concealed information not just from insurers, but from regulatory systems. It may serve to illustrate his pattern of noncompliance, which could be critical in trial strategy, even beyond the insurance fraud scope. Count 6. Staging motor vehicle crash. Statute 817.234. Second-degree felony. This refers to the deliberate orchestration of a motor vehicle accident, typically to support a fraudulent insurance claim. It criminalizes staging any motor vehicle collision, regardless of whether injuries occur, if done with intent to commit insurance fraud. It is a second-degree felony, carrying a potential penalty of up to 15 years in prison, 15 years of probation, and a $10,000 fine. DeWitte is charged with this offense for conduct on March 22, 2020, distinct from, but thematically linked to, his October 11, 2020 charges involving intentional collision participation. This charge complements others like false insurance applications, March 22 and 29, 2020. Failure to provide required vehicle info as a registered sex offender. Organized scheme to defraud. These all point to a coordinated effort to manipulate physical events and paperwork for financial gain. The crash equals staged performance. The paperwork equals scripted follow-up. The insurance claim equals intended payoff. This charge bolsters the state's theory that DeWitte wasn't simply bending rules. He was choreographing entire scenarios for profit, blending elements of performance, deception, and financial manipulation. Here is a detailed breakdown of a layered scheme. Foundation. Falsified insurance applications, allegedly misrepresenting drivers, usage, or ownership. March 22 and 29. Vehicle concealment. Omission of vehicle info, possibly used in crash staging, required by sex offender registry. Execution. 2 alleged crashes, March 22 and October 11. 1 staged, 1 orchestrated for insurance benefit. Claims and payout. Insurance claims stemming from staged events. Financial gain. Allegedly receiving property/value from false claims. Pattern and coordination. All of this wrapped into a formal scheme to defraud charge. Count 7. False and fraudulent insurance claims under $20,000. Statute 817.234. Third-degree felony. This is centered on allegations that DeWitte knowingly submitted a fraudulent claim to an insurance company in connection with an incident on March 22, 2020. This statute penalizes anyone who knowingly presents or causes to be presented a false, fraudulent, or misleading claim for payment under an insurance policy. In this instance, the amount alleged to be fraudulently claimed is less than $20,000, which classifies the charge as a third-degree felony. Maximum penalties include up to 5 years in prison, up to 5 years of probation, up to $5,000 in fines. The charge is closely linked with other events on March 22, 2020, including a staged vehicle crash on the same date, a false insurance application, failure to disclose a vehicle as required under sex offender registry laws, communications fraud, and organized scheme to defraud. Together, these suggest that DeWitte allegedly staged or manipulated a crash, filed a claim for damages under false pretenses, and sought monetary compensation, all part of what prosecutors frame as a larger, coordinated insurance fraud plan. This charge strengthens the prosecution's portrayal of DeWitte not just as someone who staged physical events, but who followed through with false supporting documentation and financial gain efforts. It's a bridge between the crash and the cash, filling in how the fraud allegedly played out through the insurance system. Count 8. Obtain prop by communicat fraud prop over 300. Statute 817.034. Third-degree felony. And it refers to knowingly using deception via communications, phone, internet, paper trail, etc., to unlawfully obtain money or property valued over $300. This statute falls under Florida's broader Communications Fraud Act, which criminalizes schemes to defraud where individuals use false representations through any medium of communication to unlawfully acquire someone else's property. In this specific tier, the value of property involved must be greater than $300, but less than $20,000. It is classified as a third-degree felony, punishable by up to 5 years in prison, 5 years of probation, and/or a $5,000 fine. The charge is linked to conduct on March 22, 2020, the same day as a staged vehicle crash, a false insurance application, a fraudulent insurance claim. According to the records, prosecutors allege that DeWitte used false or misleading claims and documentation to extract over $300 in property or payment from an insurance company, likely in connection with the staged crash event. And count 9. Organized scheme to defraud under $20,000. Statute 817.034. Third-degree felony. It accuses DeWitte of engaging in a systematic plan carried out over time to unlawfully obtain money or property through deception. The statute targets a systematic, ongoing course of conduct with intent to defraud or obtain property by using false or fraudulent representations. A violation involving under $20,000 is charged as a third-degree felony, carrying penalties of up to 5 years in prison, up to 5 years of probation, up to $5,000 in fines. This charge doesn't hinge on a single act. It highlights an alleged pattern of deceptive activity stitched together by common intent. This charge is tied to alleged actions on March 22, 2020, which include a staged motor vehicle crash, 2 false insurance applications, submission of a fraudulent claim, failure to register vehicle info as a sex offender, obtaining property via communications fraud. These events, taken together, form the basis for the state's allegation that DeWitte knowingly orchestrated a coordinated fraud strategy, not an isolated incident, but a sustained scheme to manipulate insurers and regulatory systems. This charge is the conceptual glue that binds the others, where the fraudulent claim is the act. The scheme to defraud is the storyline. It gives prosecutors a narrative backbone. What made this possible was Jeremy's repeated attempts and claims to defraud insurance companies and stage accidents because many years ago, he actually won a claim with an insurance company. There was a non-disclosure singed in the case, so it is unclear the amount that was awarded. DeWitte's legal history also includes a civil case from 2016 where he sought to remand an insurance dispute case against Foremost Insurance Company back to state court, arguing the amount in controversy was below federal jurisdiction limits. The court denied his motion, noting his medical bills from the accident exceeded $100,000. He also faced petty theft charges in Lake County in 2022 related to a polygraph test payment. The case of DeWitte v. Foremost Insurance Company involved a dispute over underinsured motorist benefits. Jeremy DeWitte, plaintiff, and Foremost Insurance Company, defendant. On December 30, 2015, Jeremy DeWitte filed a complaint against Foremost Insurance Company in Florida State Court. He was seeking underinsured motorist benefits, claiming he suffered various damages, including permanent bodily injury and medical expenses, due to an automobile accident with an underinsured driver on January 4, 2014. DeWitte's complaint stated that the amount in controversy exceeded $15,000. Foremost, however, removed the case to federal court, asserting diversity jurisdiction, which requires the amount in controversy to exceed $75,000. DeWitte subsequently filed a motion to remand the case back to state court, arguing that the $75,000 jurisdictional threshold for federal court had not been met. He also sought attorney's fees related to this motion. Foremost argued that the amount in controversy clearly exceeded $75,000. They presented evidence, including DeWitte's medical bills, which totaled over $100,000, and a lien claim from Orlando Health Incorporated for $112,000. The United States District Court for the Middle District of Florida denied DeWitte's motion to remand. The court reasoned that while DeWitte's complaint initially only claimed damages exceeding $15,000, the evidence presented by Foremost demonstrated that DeWitte's economic damages alone, medical bills and liens, surpassed the $75,000 federal jurisdictional requirement. The court noted that medical bills related to a plaintiff's treatments are sufficient to establish the amount in controversy. The court determined that the amount in controversy satisfied the requirements for federal diversity jurisdiction. The court denied the motion to remand, citing medical bills exceeding $100,000, a lien from Orlando Health for $112,000, policy limits of $100,000, demand letters for $90,000 and $100,000, given little weight but noted. On September 26, 2016, the court issued a final order of dismissal with prejudice, officially closing the case. And yes, DeWitte was later involved in numerous criminal charges and civil legal issues, but they were unrelated to the Foremost case. After settling the insurance dispute in 2016, Jeremy DeWitte became widely known for a pattern of criminal behavior including police impersonation, sex offender violations, insurance fraud, and tax fraud. He is currently serving a combined sentence of over 7 years in Florida State Prison for these offenses, and will serve 41 months in federal prison after the 7 years for the tax fraud. Jeremy is set to go to trial yet again on July 21st in Orange County. Although it has been delayed a few times, I truly hope it actually does go forward in a few weeks. I do plan on bringing it all to you and hope you will watch as I do. Thanks for watching this latest video, and please, if you have any questions, put them in the comments and I will do what I can to answer you. Hope you enjoyed, and if you did, please feel free to hit the like and subscribe so you get alerted for future content. Thank you.